Swayam Prabha. Digital India. Educated India.
Hello students, this is Professor Anupam Jha and I will be trying to tell you and make you understand a new school of jurisprudence today, and that school of jurisprudence is sociological school of jurisprudence. And we will try to understand in this lecture about the founder of this school, who was Roscoe, and then we will try to understand about this school of jurisprudence and how and what were the main tenets of sociological school as propounded by Professor Roscoe. And he specifically wanted to focus upon 4 or 5 important things: how to make law more effective, how to achieve purposes of the legal order, and then what are the subject matters of a legal system and what is its scope. Then he also tried to tell us what was the meaning of the term social engineering, and then what are the meaning of the word interests, what are its types, what is the meaning. He also tried to tell us what are the different types of interests and what do they mean. Then he further said that what are the various ways in which those interests can be secured, and then he said about the balancing of the different interests, and finally he told about the jural postulates. So, today we will try to understand these very important elements of sociological school as propounded by Professor Roscoe, and if time will permit, then we will also try to understand some other scholars of sociological school. Now, let us try to know about the founder of sociological school. He was Professor Roscoe, and he was born in the year 1870 when US was witnessing different kinds of internal disturbance in the form of civilian problem, that there were different states in the country and how those countries they were fighting against each other. So, in that year he was born in Lincoln, which is in Nebraska state, and you might have heard about Chicago, which is in Illinois state, and Kansas, which is in the state of Kansas. So, just nearby these main states of central states of United States, there is another state, Nebraska, where he was born. Interestingly, he did not study law like nowadays the students study law just after completing their 12th standard, but in those times he could have not studied this, because even today in US that system is not there, that just after your school examinations, senior school examinations, you can start studying of the law. So, he graduated in botany from the University of Nebraska, and after doing his masters he joined law, but still he did not obtain the law degree. So, masters in botany, and thereafter he tried to study law, but because of the age or because of some other compulsions he could not earn the law degree. But he developed his interest in botany later and completed his PhD obtained this degree from the same University of Nebraska. And then because he had interest, so he started taking classes in the law school of Nebraska law faculty, and there he started to take stints in the study of law, because he had already a PhD degree, so he could have taken the classes. And interestingly, what happened that he started taking lot of interest in the study of law, and you see that his rise to becoming the dean of one of the most reputed law schools of the world, Harvard Law School. There he became the dean in the 1916. So you see that 30-40 years of his life, just when he was 46 years, he became the dean, one of the most reputed law schools of the world, that was Harvard Law School. So you could have seen that how this professor, who was not initially having interest in law, but later on he developed such a magnificent interest that he became the dean, and there he started to take interest in the political developments, economic developments. And you might have known about the Franklin Roosevelt, who was the president of USA, and he had initiated the New Deal policy. And who supported it initially? Roscoe Pound supported the New Deal, but later on he did not support it. And one of the important contributions in the field of academics was that Professor Roscoe Pound published the scope and purpose of sociological jurisprudence, and that was published in 3 parts in 1911 to 1912, and those 3 parts became immediately famous, and now it has become a classic. If you want to study the original monograph of Roscoe Pound's contribution, you must have to refer this Harvard Law Review publication. He also published a survey of social interests in Harvard Law Review, and finally his book, which became the magnum opus, 5 volumes book on jurisprudence, that was published in the year 1962. So in this slide you might have seen that how Professor Roscoe Pound, who was initially not having that much of interest in law, but later on he developed such a huge interest in law that he became not only the dean, but he also founded a new school of jurisprudence that was called subsequently Sociological School of Jurisprudence. So today we will try to understand this school, and we will see that how this school, where this school has focus upon. So first of all, we will try to understand the basic tenets of this sociological school. This school says that when you make laws, when you interpret laws, when you apply laws, then you should take account of the social facts. Now it means that even when a person has the power to apply the law, but if that person will not know the social fact and then he or she will apply laws, then sociological school says it's not right. So sociological school says even making of laws, when legislators make laws, it will not be because of the power of the legislator to make laws of any kind, but legislators should make laws keeping into account the social facts. So how to know the social fact? 3 elements are important. What are those 3 elements? You can see that the factual study of social effects of legal administration. law is being administered in a society, in a country, but what are the social effects in terms of facts? So, factual study, empirical study of the social effects of legal administration, that is very important. Unless we do not know the effect, social effect of a particular law, we cannot make another law in that field. We should not make an amendment in the law in that field. Another is social investigations as preliminaries to legislation. Social investigation, you have to go to the society, you have to go to your roots, you have to go and know, investigate that what are the problems faced by the society in the given time, and then only you come back as legislator. If you want to make laws, that is fine, because you have gone back to see the problems of the society and then you have tried to make a law or to reform the laws. And further, third is constant study of the means for making laws more effective. It is not that there was a day when you made the law, but you also have to constantly see, study that how those laws can be made more effective. So, this is a kind of constant knowing about the social facts. What are the social facts? Because sociological school starts with this premise. You have to know about the social facts. Once you know the social facts, you can be going further, you can be a successful legislator, you can be a person who can apply the law as judge, and therefore, that is very important to know the social facts. Further, he also says that laws need to be made more effective. And how to make those laws more effective? Now, he has also given solutions. He is not the person who only finds the problems, but he says that we have to find solutions, and he says that laws can be made more effective, but 5 elements are required. What are those 5 elements? First is a study of the judicial method. You have to study that what is the method which is used by the judiciary, whether judges look at the DNA evidence, the new evidence supported by science, or they are just looking at the bygone era of the past. So, you have to look at the judicial method, how judiciary, what are the methods which are used by the judiciary in the times of COVID. If the judiciary will not make the application they will not use the application which are new, which are innovative, then it will be difficult for the common people go to the courts. And next is sociological study of the legal history. History reading is important, the legal history is also very important, but sociological study of legal history, that for the first time he said that it is not that just legal history, because looking back at history involves so many perspectives, and one perspective is that of sociological study of the legal history. What does that mean? That means that the legal history might have evolved since the times of ancient civilization, but then we have to study that what happened when the Britishers came here, what happened before Britishers, and we have to look at that in the modern times how the legal system that can be made more effective. Next was allowance for the possibility of a just and reasonable solution of individual cases. So, individual cases might be so many, there might be so many disputes, but what he said, just and reasonable solution. Now here comes the difference. He was not only interested in administration of justice and law according to the positivism, according to the law which was there, but he said it must be the effort of the judges and the legislators that a problem may be solved by a just and reasonable means, and the solution should also be just. So this possibility has also to be explored, and therefore you have to look at the society, the social facts. And then he says that achievement of the purposes of various laws. Various laws you make, but you have to constantly look at it, that whether you have achieved the purpose for which the law was made. And therefore, if you do not study this and you just say that law has to be amended, law needs to be reformed, that will not be good for the society. He says that you have to look at the purposes of various laws, and you have to see whether you have achieved those purposes. If you have not, why not, and what are the further actions which are needed. So these are the important things which Professor Roscoe said, that if you want to make laws more effective, you have to have a separate ministry of justice, law and justice. So as we can see that every civilized countries, they have the ministry of law and justice, because law and justice is a important wing of the state, and if the separate ministry of law and justice is there, then what will happen, that they will start doing these activities, that what are the social facts which are there in the society. So this is important, and therefore we must understand that Roscoe Pound's view, that how the laws can be made more effective. In the next slide, what we will see, that how the legal order that can achieve the purposes of law and purposes of the legal order. How to achieve, and Professor Roscoe Pound suggests 3 ways to achieve the purposes of the legal order. The first is by recognizing certain interests. There are many interests of the society, but you have to recognize certain interests which may be individual, which may be social, and which may be public interests. So the purpose of legal order can only be achieved if you constantly recognize the certain interests of the society. So the word interest has come here. Earlier he had said about social facts, and now he says that social interest. What are the interests? So social interest, public interest, and individual interests. Next is securing of those interests within the limits as defined. So once you know the interests of the society, then the second step, what is said by Professor Roscoe Pound, was that you try to secure those interests, but it must be within the limits which are defined by the legal order. But it should be the constant exercise, that how to secure the interests which are coming from the society, and how law responds to it, that is very essential. And then the third thing what he said, that you have to define the limits within which such interests will be legally recognized and given effect to. So you first of all know the interests, then you try to secure the interests, and then you have to define the limits within which those interests will be legally recognized and given effect to. So these are the 3-step procedure. This is a procedure which was made known to the people by saying that how can a purpose of legal order can be achieved, and perhaps he was right when he said that you find out the interest, you find out securing the means by which these interests can be secured, and then you define the limits in which these interests can be legally recognized. Now, in this slide you will find that what is the scope and subject matter of the legal system. He says that when determining the scope and subject matter of the system, 5 things need to be done, and those 5 things, the first is preparation of inventory of interests and classifying them. So, making of inventory is a great exercise. It means that the policy makers, they will have night and day working for this making of this inventory. If you have the inventory, then you can know that when a social interest can be secured, how the social interest or individual interest or public interest can be recognized, what can be the limits of such recognition. So, you have to prepare the inventory. It is not mechanical science, it is not a science by which you can just collect some of the things in a particular field, but it will involve substantial effort to go to the society, to know the social facts, and then come back and find that okay, this is the interest of the society, and you prepare the list of it. The second is selection of the interests which should be legally recognized. Now, this is a constant process. You prepare the inventory, but you cannot select the interests, then what will happen? This will just remain in the box and that will bite the dust. It should not be there. What should be a dynamic society do? A dynamic society should select the interests which should be legally recognized. Then legal recognition of interest. Our interest has not been legally recognized. There was a time when there was no trade union. There was a time when environment was not that much important. The protection of environment was not that much important, but now the time has come, and so many years before the time had come that the interest of the workmen, and now the time has come that protection of environment, they have become so important. So, legal ways of recognizing, there might have been certain debates, there might have been certain statements, but legal recognition of those interests, those are very important. And then demarcation of the limits of securing the interests so selected. How will you demarcate the limits? You know that this interest cannot be secured, you will have to demarcate. Now, this involves executive exercise, this involves lot of discretion in the minds of policy makers. So, the policy makers will have to be on vigil, they have to be constantly on their toes to see that how the limits can be drawn, how can we demarcate the limits in which those interests which are selected, they can be secured. Next is that consideration of the means whereby laws might secure the interests when these have been acknowledged and delimited. So, what would be the means? You have to look for the means also. Will the legislator be sitting in his legislature and then he will say that no, now for the next 5 years we have nothing to do, just we have to see that what laws are debated? The answer is no. Legislators and policy makers, they have to consider the means by which those interests might be secured, because those interests have been acknowledged and those interests are delimited. So, you remember that there was the interest of having reservations in employment. So, that was interest. So, how to secure the interest, how to give legal recognition to that interest, that was the duty of the jurists, that was the duty of the legal order, and therefore, this school of jurisprudence is innovative in the sense that it wanted to shift focus from the power of the legislator to the process of lawmaking, that how law should be made, how judiciary should be going for adjudication of disputes. And finally, evolution of the principles of valuation of the interests, and that will take time. So, how the interests can be secured, what principles can be laid down, what principles can be evolving, and what principles can be evolved potentially. Now, this will take a long time, but that is what the sociological school wanted to have, that let us try to go to the society. Even when you are a student of law in the law school, you should not lose touch with the members of your society or neighborhood, because if you will lose touch of the neighborhood, you will not understand the existing problems of the society. Laws might have been made 100 years before, but laws may be changed after 100 years. And what will be the basis of change? It will not be just because of the whimsical thinking of the legislator, but it will be because the legislator has made the ground study. What are the interests of the society, how those interests can be made in an inventory, and how from the inventory you recognize some of the interests, and thereafter you fix the limits, and thereafter you find out ways to secure the interests, and finally you constantly evolve the principles of valuation of those interests. Now, after that, Roscoe Pound moves further, and here comes his novel idea. What he says, although he had studied botany, but he uses the term engineering, and he talks about social engineering. And here you have to give full attention that how this social engineering that was laid down as a main element of the sociological school of jurisprudence. What he says, that common law still bears the impress of individual rights. He was born in US, where in majority of the states of US common law was practiced, but what he found? He found that it bears the impress of individual rights. It does not talk about the rights which should be given to the society as a whole. It does not talk about the social interests. It is only talking about the individual interests. But he says that the task of the lawyer is not to just talk about the sections and provisions of the statute, but he says that task of a lawyer is to do social engineering. It is not mechanical engineering, it is not civil engineering, it is not aeronautical engineering. Have you heard of this word, social engineering? Roscoe Pound had termed this kind of engineering as social engineering. And what did he mean? He said that the aim of social engineering is to build as efficient a structure of society as possible. You know, engineers build the buildings, but Roscoe Pound said that the building of the legal order, the building of a new society, the building of a efficient society, who will do it and how this will be done? This will be done by social engineering. And therefore, he said the aim of social engineering is to build an efficient structure which the society needs. And how this can be done? He says that it requires the satisfaction of the maximum of wants with the minimum of friction and waste. There should be minimum of friction and waste, and maximization of the satisfaction of wants of the members of society. Now, that is the aim of social engineering. Social engineering does not mean that just you have to build any kind of a structure. Social engineering means that you have to build a efficient structure where the satisfaction of maximum number of wants. Wants mean that interest. Wants, satisfaction of maximum number of wants with the minimum of friction. It means that there should be robust systems of resolution of disputes, and therefore, when those robust institutions are there, then it can be imagined, and not only simply having institutions, but the people who are there, they understand the social engineering and they have the knowledge that social and individual and public interests, what those interests are and how those interests can be secured, and they constantly try to do it. Only then it will be with minimum friction and minimum of waste. And what social engineering involves? Social engineering involves the balancing of competing interests. Interests can compete against other interests. So, what Roscoe Pound said? Roscoe Pound said that the social engineer, what they will do, that they will try to balance the competing interests of the society. Now, this is the task of a social engineer. The social engineer knows how to balance it. We will also try to understand the balancing metaphor, the balancing techniques also. So, in this slide what we have tried to understand, we have tried to understand the meaning of the social engineering, its importance. Thereafter, as you know, that Roscoe Pound said there are 3 different types of interests. The first type of interest, he said, individual interests. The second type was the public interest, and the third was the social interest. But now you might be interested in knowing, because lot many times we have heard the word this interest. So, you have to now understand the meaning of this word interests. Let us try to understand the meaning of this word. Roscoe Pound defined interest as the claim which men assert de facto, about which law must do something if organized societies are to endure. What does that mean? It means that if the organized society, first of all there must be organized society, and if the organized society wants to go and sustain for a long time in the future, it will not be possible unless the wants, the claims, the desires which the members of the society they assert, and that also not on the plain paper, but they assert de facto, and therefore law must do something. If law does not do anything, then the organized society will not endure. So, he had made a prediction. If any society wants to progress and go for very long time in the same way, then can it be possible without recognizing the new interests of the members of the society? He said no, you have to look at the claims, you have to look at the wants, you have to look at the desires, which not that people just dream, but they assert, and they assert it de facto, then you can say that this is the interest of the society. Now, this interest is of three types: individual interests. What is the meaning of individual interests? He says that those claims, those demands, those desires which are involving individual's life, and they are looked at from the standpoint of the individual life, that is the individual interest. So, individual lives, my individual life is my room, my individual life is that how can I enjoy my time. Now, that in these things, if there is an interest, that can be the example of individual interest. And Roscoe gives some examples: personality, interest in the physical freedom, interest in the freedom of will, interest in honor and reputation, interest in privacy, interest in belief and opinion. Now, these are all examples of the individual interest. Then he further gives some examples, some more examples, like domestic relations, like individual interests of parents, of children, of husbands, of wives. Now, these are all in the field of domestic relations, but that is also an example of individual interest. Then he says interest of substance, like interest of property, interest of freedom of industry, interest of freedom of contract, freedom of association, continuity of employment, and some advantages which are promised. So, we have seen that he defined the individual interests, and also he gave certain examples of individual interests. So, but the basic thing about the individual interest is that individual interests are those interests which are involved in the life of an individual. Now, we will see about the public interests. What are the meaning of public interests? He said public interests are claims or demands or desires which are asserted by the individuals involved in or looked at from the standpoint of political life. Now, individual interest was looked from the standpoint of individual, but the public interest is looked from the standpoint of the political life. So, public interests, you can see that it is of two types. One is interests of the state as a juristic person. Juristic person means that state is considered as a legal entity. So, juristic person, you all might be knowing that a state is given this kind of status, that it can be considered a juristic person, and it can be sued in the court, and state can also sue individuals. So, what I was telling, that public interests are of two types. One is about the interest of the state as a juristic person, other is the claims of a politically organized society as a corporation to property acquired and held for corporate purposes. So, such kind of claims of the politically organized society, that is also the public interest. So, public interests are basically of two types, and when the state acts as the guardian of social interests, that is also the example of public interest. So, public interest is of a different category, but as a social investigator, that it can be seen from the standpoint of the politically organized society. If you can say that the state is protecting the interest of social interest as a guardian, that is, these are the ways in which you can understand about the public interests. Now, we will move on to understand another type of interest, which are called social interests. What are these social interests? Now, Roscoe says that claims, demands or desires which are thought of in terms of social life. So, initially the individual interest from individual's life, the public interest from the political life, but social interest from social life, and which are generalized as claims of the social group. This is, according to Roscoe, this is the most important category of interests, and further he says that social interests are of 5 types. The first type is the social interest in individual life, such as self assertion, opportunity, conditions of life, and that is called social interest. So, individual's life, but there is a social interest in the individual's life, that is the social interest. Otherwise, individual's life and individual's problems will be the individual's interest, but social interest in individual's life, like the opportunity and conditions of life, what are the opportunities which are there, this is a social interest. Next is social interest in the general progress, such as economic progress, political progress. So, society as a whole, they are interested in these things, whether economy is progressing. You may have thought sometimes that suppose if the government of the day does not work for the economic progress, will you give vote to that government if you have the right to vote, or if you have become the major and then you go to the booth. So, the thing is that economic progress everyone wants. Political progress, there is a social interest in the political progress, because if the political progress will not be there, then the social interest cannot be recognized. So, social interest is there in the political progress too. And then the next is the social interest in general morals. What are those? Like those laws which are dealing with prostitution, those laws which are dealing with drunkenness, and those laws which are dealing with gambling. Now, gambling everyone enjoys, but there is a social interest that because in gambling what happens, that a person may lose lot of hard earned money. Now, what will be the social interest in that case? Social interest will be that gambling should not be encouraged, and it should not be always be there, and that should not be the way of money making only. So, these are the general morals. There is a social interest in the general morals of the people. Next is the social interest in the security of social institutions, such as domestic institutions, religious institutions, political institutions, economic institutions. Now, again these are the social institutions, like the institution of marriage. This is a social institution, and there will be a social interest in the protection of this institution of marriage. Likewise, religious institutions are also taken into consideration by the society, and social interest will be that religious institutions, they should be protected, they should not be vandalized, and therefore, social interest is there. Economic institutions also, if someone will say that the RBI or the other institutions like banks and insurance companies, if there should be no law on it, it is not right, because there is a social interest also. You might remember that there was a time when banks were nationalized, because there was a social interest. At that moment of time, there was the social interest that banks were only earning profits. Banks, they did not care for the society. Take the example of companies also. So, such economic institutions like companies, partnership firms, they should also be looking at the social interest. So, there is a social interest in these economic institutions too. Next was social interest in the general security of safety, health, peace and order, security of acquisitions, security of transactions. So, this is also a social interest. It is not that the general health, if that will be deteriorating. You remember the COVID times, there was a social interest that vaccine should be made. There was a social interest that people should not die as just another kind of victim of such kind of pandemic in other nations, but it should be that the health of the nation that needs to be protected. That was a social interest. The next social interest is in the conservation of social resources, such as conservation of natural resources, conservation of human resources. So, such is also the interest of the society. If the natural resources are not conserved, then the society will become angry. So, even when any government will come, but then if the government or even the civil members of the society, if some civil members of the society, if they will try to just destroy the natural resources, that is not the right thing. So, what we have seen in this slide, that Roscoe tried to distinguish between three main types of interests. One was the individual interest, the second was the public interest, and the third was the social interest. I for individual interests, P for public interests, and S for social interests. IPS, these are the three interests. Interests are three, IPS. Now, the next what he said, that what are the means of securing the various interests. So, he says that you can do one thing, you can make a device like engineers do. They make a device and then they solve the problem. Here also he said you make a device, but what kind of device? This will not be a mechanical device, this will be a device of law. You have to make a person, you have to give a status of that interest as a person in law. So, suppose if you want to say that company's interests should be protected. Now, how it will be protected? You have to make the company as a legal person. If you say that state has to be such kind of entity which can protect its rights, how can it be done? You give a legal person, legal personality to the state. So, device of legal person is very important. Next is that you attribute claims, duties, liberties, powers and immunities. Sometimes you have to give power to an individual, sometimes you have to give immunity to an individual or a legal entity, sometimes you have to give liberties and sometimes you have to say that duties are there. So, you have the capacity, the legal order has the capacity to attribute the particular interest with these kind of things. And finally, availability of remedial machinery aimed sometimes at punishment, sometimes at redress and sometimes at prevention. So, the remedial machinery should also be there, because otherwise interests will not be secured, and therefore, what Roscoe says that if remedial machinery is not there, if the punishment is not, the provision for punishment is not there, if the redressal mechanisms are not there, if preventive mechanisms are not there, then you cannot secure the various interests. Then more importantly, what he said, that once you know the interests of the society, what you have to do, that you should know, this is an engineer's knowledge, you should know how to balance or weigh the different interests. So, how it will be done? Professor Pound says interests should be weighed not on different planes, but on the same plane. That is very important. As a social engineer, you must know that you have to weigh the interest, you have to balance, you have the balance, but you should not balance one interest, one type of interest with other type of interest. So, suppose in one balance, one part of the balance, if there is individual interest, you cannot place public interest in the other part of the balance. So, what it says, interest should be weighed on the same plane, and then he says balancing of individual interests against a social interest not permissible. So, you have to weigh the same type of interest, individual interest versus individual interest, public interest versus public interest, social interest versus social interest. And relating to that, what he says, transferring the interest involved onto the same plane. Do not do that you transfer the interest of one plane to the other. So, what you do, that you have to look at the interest and you have to put the same type of interest in the other balancing tool. What he says, that giving effect to an interest depends upon the texture of legal institutions. What is the texture of legal institutions? Whether legal institutions are progressive or they are very conservative. What kind of, whether they are liberal or whether they are conservative. If they are liberal, then they can recognize a new interest. If they are conservative, they may not recognize the new interest. So, it depends upon the institution also. So, what social engineers have to do, that social engineers must be knowing the balancing technique, how to balance the different and sometimes competing interest. Sometimes you have to see that one individual interest is competing with the social interest. Now, in that case, the weight of social interest will be high and the weight of the individual interest will be low. So, in that case, you will have to balance, and the balance will be very difficult because the social interests have to be given more weightage, and in that case social interest will win. But at the same time, Roscoe Pound says you should not place the social interest in the other part of the balance. So, that is also very difficult. And thereafter, he propounded some jural postulates, and he said that there are 5 jural postulates. The first is about the contract law, the second is about the private property law, the third was about criminal law, the fourth was about strict liability, and the fifth was about negligence. These were the 5 jural postulates which were propounded by the Professor Roscoe Pound. Now, finally, we will evaluate the sociological school and we will see that what kind of word which was used. Was engineering word a right word? Many people say that this word was vague. What is waste and friction in relation to the conflict of interest? That was also not very much explained by Professor Roscoe Pound. And what was the balancing metaphor? Balancing metaphor was also not quite satisfactory because sometimes it leads to different results. So, today what we have tried to see, we have tried to understand the various basic foundational ideas of sociological school as propounded by the Roscoe Pound, and we saw that the sociological school favors the knowing of social facts, and who does it? The judges do it. Who does it? The lawyers do it. Who does it? The legislators do it. And how they do it? They have to know the social interests, they have to recognize the social interests, and then if they make laws, that laws will be more effective, and then if the judges will decide the disputes, the judgments would be more effective, and then if the executive does it, that will be more effective. So, sociological school of jurisprudence was very, very important to understand this new school of jurisprudence. I hope that you might have understood this topic today. Thank you so much for giving your kind attention. Have a great day. Thank you.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I want to tell you a little bit about what sociology is. In order to go ahead and study sociology, one of the things you need to develop is a sociological way of thinking. Now, this capacity to think in a sociological manner was termed as the sociological imagination by an American sociologist called C. Wright Mills in 1959. He argued that in order to think in a sociological manner, you should be able to have two different skill sets. The first skill set would require you to have the capacity to think beyond the problems that individuals face. So, if you encounter a problem that some one individual is facing, you should be able to connect it to a broader public problem. Mills gave the example of people in his neighborhood. He says if there is one person who is unemployed in the neighborhood, that seems to be an individual problem, but as a sociologist, you're expected to dig around a little. So you come across a couple of other people in your neighborhood who are also unemployed. That indicates to you that rather than being a specific problem, there is a larger public issue at hand. So as a sociologist, you're supposed to look at individual problems and see how they are connected to broader public issues. The second capacity that you're expected to develop as a sociologist is the capacity to link an individual's biography with history. Historical thought may not come to you as the first thing that's connected to sociology, but it plays a pretty important role in the field. So Mills argues that rather than looking at a problem in the here and now, it's important to trace that long historical trajectory that may be connected to this individual problem. Let me give you an example from India, right? Let's say you look at the women in your family. Let's see at what age do they get married. So you may see that your sibling is getting married at the age of 25. Go back one generation. At what age did your mother get married? You may find that she got married a little younger, let's say 21. Go back another generation. At what age did your grandmother get married? You may find that she got married even younger, 18 or possibly even younger than that. So this capacity to see how the history of a family then influences the age at which your sibling got married, that is the capacity to bridge the biography of a person, or rather by biography we can also think of the biography of a particular problem with history. What has happened in the past? How is that connected to this individual or this problem in the present? Thank you.